Number 1 is votes.
Okay.
Okay, RGC backup. It was supposed to be here a long time ago. Can you hear me in Department of Corrections?
Here she come right now. She on the way.
Who am I speaking with?
It's Terrell.
Who is this?
Victor Terrell. I can go get administration for you.
Well, let's see. Yeah, because you're not the person I was looking for.
Okay, I'm about to go get her for you.
Thank you.
I have a video for you. So here she comes shortly.
Thank you.
Yeah.
Can you tell me about the party? Can you hear me in RGC?
Yeah.
Hello?
Yes. She still ain't came.
What's your name? What is your name?
Camel.
Okay, this is not the inmate I'm looking for. I don't know which court you're supposed to be in. The inmate that was supposed to be in my courtroom was supposed to be here at 10:30, almost an hour ago anyways, and you're not the inmate I'm looking for, so I'm going to log off.
Okay.
Thank you. Okay. Okay, ladies and gentlemen, you can fix your attention to the screen here. I have some instructions. Ladies and gentlemen, I am Judge Kristen D. Simmons, and it is my pleasure and privilege to welcome you to the 54A District Court of Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have a right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that would help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. This glitch only happens when the jury is here, just so you're aware. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of two ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. Please excuse me, the Department of Corrections is zooming back in. Good morning, what's your name?
Raphael Hinton.
Okay, Mr. Hinton, we have to reset your matter because you were scheduled for 10:30. It's almost 11:30 and I'm in the middle of a jury trial. January 9th at 8:30. January 9th at 8:30, okay?
I mean, what do I got to do to stop us from rescheduling over and over and over? I have no control over it. They keep rescheduling over and over.
We don't have any control either. You need to tell the administration at the Department of Corrections to get you here on time.
All right.
Thank you. Okay, pardon that interruption. I will now ask you all to stand to swear truthfully, fully and honestly, to answer all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. All rise. And raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, say I do.
I do.
Thank you. You can be seated. Let me introduce some of the staff today. I have Miss Addie Nash. She is my judicial assistant and my court recorder. Today, we borrowed the Chief Judge's staff member, Mr. David Warnsley. He is going to be the court officer for today. This is a criminal case involving the charge of an assault, which I will explain more fully later. This charge has been made against the defendant, who is Jesse Cockrum. The defendant's attorney is Mr. Stephen Milks. Mr. Milks, please stand and list any witnesses you anticipate calling in this trial.
Yes, thank you very much, Your Honor. And morning, everyone. My name is Stephen Milks, as the judge has already said. I'm representing Mr. Cockrum, who is sitting here to my left. And I'm also going to be calling a Felicia Stevenson.
Mr. Brodowitz is the assistant prosecuting attorney. Mr. Brodowitz, please stand and list any witnesses you anticipate calling at trial.
Thank you, Your Honor. Good morning, everyone. My name is Jeff Brodowitz. I'm the assistant prosecutor. As Jeff said, the witnesses I anticipate calling today are Mr. William Rayborn, Miss April Rayborn, and Miss Kimberly Martin.
Thank you. Does anyone in the jury box or anyone waiting to get a seat in the jury box know the defendant or any of his lawyers or the witness's name? If you do, just raise your hand. Nobody knows anyone? Okay, very good. We believe this trial to last 1 day, meaning today will be the only day needed to complete this trial. If you believe that the length of the trial will be a real hardship for you, please raise your hand now. Very good. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 or 3 hours at a time? Or does anyone have a sight or hearing problem? So if that's you, just raise your hand. Okay, is that a hearing problem, sir? Is that a yes?
Yes.
Okay, but you got our device. Can you hear us well with the device? Very good. Anybody else have any issues that they need to raise their hand about? Yes, sir.
Is it all right to stand ever so often?
It is completely fine for you to stand every so often. We will not be sitting for 2 and 3 hours at a time, just so you're aware, okay? I can't sit for that long and I don't have any medical issues, okay? Okay. Any other issues? Anyone need to raise their hand about? Everyone can hear me? Very good. This is a criminal case. The paper used to charge the defendant with a crime is called a complaint. The complaint in this case charges the defendant, Jesse Cockrum, with count 1, alleging that on or about June 6, 2023 at 1115 White, City of Lansing, Ingham County, State of Michigan, that he allegedly committed the act of assault, that he did make an assault upon a William Rayborn and or upon an April Rayborn. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that defendant and jury can hear the charges. You must not think that it is evidence of his guilt or that he must be guilty because he has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. Excuse me. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. And we will now begin with voir dire. Mr. Broderick.
Thank you, Your Honor. Good morning again. I think it's still morning. Good morning again, ladies and gentlemen. As I said, I'll reintroduce myself. My name is Jim Brodowitz. I'm the assistant prosecutor here. As the judge stated, myself and Mr. Milks, we're going to ask you some questions here. Not trying to pry, not trying to embarrass anybody. We just want to get the most fair and impartial panel that we can. All that I'm looking for is that you keep an open mind so that we can resolve this with a fair trial. So to start off, has anyone here ever served on a jury before?
Yep.
Okay, and you and Mr. Smith?
Yep.
What type of jury was it? Was it criminal jury, civil jury?
Like this, it's a small jury.
Or was it for, I guess, was money at stake or was it a crime that had been committed? Okay. Do you remember what the trial was for?
One girl assaulted another.
Or what was it?
One girl assaulted another girl.
Okay, so it was an assault trial again. Were you able to reach a verdict in that trial?
Yes.
Okay. And do you recall what that verdict was at all?
Yeah,
Okay. So does anyone here, I know the judge already kind of asked this, but does anyone here recognize myself, the defense attorney, the defendant, anybody from the prosecutor? Does anyone know anybody from the prosecutor's office, public defender's office?
No,
Okay.
I don't know the defense attorney at all, but I did see him in the bathroom earlier.
Okay. And you're again, Mr. Price, correct?
Correct.
Okay. Yep.
Platonically though, right?
Yes.
Oh, God.
There we go.
Help us, Lord. And just for the record, the defense attorney had already disclosed that to the court. I don't know the nature of the conversation, but he indicated it was nothing about this case. You agree?
That is correct.
Okay, you can proceed.
Okay. And again, just to clarify, no one's ever had any contact with the prosecutor's office before as a victim, defendant, witness, anything like that?
With the prosecutor's office in general?
For Ingham County.
Yes.
Okay. And would that have been in your capacity as a police officer, sir?
That is correct.
And were you called, I'm guessing you were called to testify at times?
Many of them.
Okay. And would that interaction with the prosecutor's office impact your ability to be fair and impartial here today?
Absolutely.
Okay. And then I believe I saw a hand raised from Mr. Keys, is it?
Yes.
Yes. How were you involved with the?
Drunk driving ticket?
Okay. And that was, I'm guessing, your ticket?
Yes.
And was that resolved?
Yeah.
And would that interaction in any way
Possible.
impact your impartiality?
It's possible.
Okay. So outside of, as we already, I think I've already said with Mr. Smith, does anyone else have any friends, family, anyone involved in law enforcement? And then Mr. Clyde Smith, you already said that your former experience as a police officer wouldn't impact your impartiality.
Absolutely.
Okay.
Juror number 7.
Yes.
Yeah, I mean, I work in public safety, so I have a lot of friends that are in that capacity.
Okay. And would, now, between us here, I don't expect any police officers to be called here for their testimony, but would your experience working with in public safety impact your impartiality here one way or the other? Okay. And so would that, I guess, just to would you be giving them more weight to one side than the other?
I would say probably so, yes.
Okay. All right. So moving on from that, so the charge in this trial here is on the complaint, it's technically listed as assault or assault battery, but specifically the charge of assault, as the judge said. Now, assault has several elements here. Sorry, before I get into that, has anyone here ever had a family member that has been, close friend, anybody who's been the victim of an assault, anything like that?
Yes.
You have, ma'am?
Mhm.
Okay, family member, close friend?
Family members
Okay,
and friends, yes.
okay. And were any of those cases ever brought to trial? No? If you know.
My family member, I don't believe it was. I've had several friends, coworkers of mine that have gone through the criminal process. I don't know what the verdicts were or what happened with them.
Okay, fair enough. So now going into it, so the crime of assault has several elements, which the judge will instruct you on later. But first, it's that the defendant either attempted to commit a battery or that he had or did an act that would cause a reasonable person to apprehend an immediate battery. We'll also get definition of that is a battery is any violent or offensive touching of a person or anything closely connected to a person or someone else. The second element that I have to meet is that the defendant either intended to commit the battery upon the victims in this case, or made them reasonably fear an immediate battery. And that finally, that the defendant had the ability to carry out that, that battery. Does anyone have an issue with those elements? So I expect also that there may be some testimony that is elicited here today that will be about a relationship that exists between the defendant here and one of the victims, that being that a relationship exists between them prior to this incident, revolving around one of the victim's ex-wives. Does anyone believe that incidences like this should be, kept in between people and kept out of the courts? So one of the elements that needs to be proved is the element of intent. So does everyone recognize, does anyone have an issue with the fact that intent can not only be shown by actions, but words as well? Everyone agree to that? Okay. And do you believe as jurors? So let me see, I will ask Mr. Vogt? Okay, we haven't, do you believe that based on the testimony and the evidence you see here today, you could be able to interpret the, or correctly judge the intent here today?
Yes, I'm not sure what that.
Okay, no, fair enough, but based on the evidence that you will hear and see, you believe that you can make a judgment as to what another person's intent was?
I hope so.
Okay, fair enough. And then Ms. Rice, same question. You believe based on what you hear here today, you can determine what the intent was based on what you hear and what you see?
I believe so.
Okay. And then in general, does everyone understand the difference between an intentional act and an accident? And do you believe you can tell the difference between the two? Okay, fair enough. So now most of the evidence that I expect you'll hear today will be testimony from witnesses specifically. Is anyone here expecting any sort of, independent eyewitness with a 100% perfect memory to come in and say exactly what happened? Okay. Is anyone expecting any sort of high-piece technology or anything, you see on TV, CSI type stuff to, come in and recreate the event exactly as it was? Okay. Does everyone agree that the witnesses up there are going to be human beings with different motives, different memories, different things that are, impacting, what they can remember, and that you as the jury are the sole determiner of the witness's credibility up there? Does everyone agree with that? So the other thing I'll hit on really quickly here is the judge mentioned that the standard I have to meet is beyond a reasonable doubt. Now, people like to do it in terms of percentage, so I'll do it. So Miss Rice, what in your mind would be on a scale of 1 to 100 be reasonable doubt?
Question.
Okay, so on a scale of 1 to 100, giving a percentage, how convinced would you have to be of one side of what I'm having to prove for it to be beyond a reasonable doubt?
I can't think of a percentage, I guess, but if there was stuff on the question, if there was.
Okay, is it, I guess, let me rephrase it this way. Are you expecting me as the prosecutor here to prove, to be 100%, absolutely this is exactly what happened? Okay, but.
So if there's any sort of reasonable doubt.
Okay. Fair enough. And then Mr. Davenport, same question. 50%? Okay. So reasonable doubt is I would say is a bit more than 50. So the example I like to give is this is so if you walk out of your house and you see that the sidewalk is wet, the grass is wet, there's, drops of water on your car windshield, it is reasonable to assume that it rained out that night, correct? Okay. But is it also not, I guess, is it also possible that in the night while you were sleeping, somebody got up on your roof with a garden hose and started spraying water everywhere? Is that also possible? Okay, but is that reasonable? Okay, so that's the standard just we're looking for here, is that it's beyond a reasonable doubt based on the evidence here presented. Finally, the final question I have is ultimately if a guilty verdict is found, does everyone understand that punishment in this matter is solely the determination of the judge, not of you, the jury? Does everyone understand that? Okay, and would anyone here take possible punishment into account during deliberation? I have no further questions, Your Honor.
Mr. Milks?
Thank you, Your Honor. Morning, everyone. Thank you very much for being here. I introduced myself a little bit earlier, but again, my name is Stephen Milks, and it is my pleasure to represent Jesse Cockrum, who is sued to my right. I'm a local defense attorney here in town, and as it's already kind of been noted, just like to ask you a few questions, get to know you, and everyone listening here as well. There may be some additional questions that come up if anyone else gets called up. First and foremost, what I can guarantee you is the fastest way to get picked for a jury is to just not talk. Okay? It's an important time for us to actually sit down, talk, and kind of go over a few things. All right. So first and foremost, Mr. Smith, I just wanted to confirm, you said that you have been on a jury before for an assault and battery. Is that correct?
Yeah, fully, more or less.
Okay, an assaultive crime or something along those lines?
Yeah.
Okay. All right. Thank you, sir. All right. By show of hands, who has ever been through a divorce or has had friends that have gone through a divorce before? Just by show of hands. Okay, just about everyone's hand has been raised at this point. Let's see. Bogus, thank you. Mr. Bogus, don't want to know who. I'm not here to put you on the spot like that. Was it a contentious situation, the divorce?
There have been.
There have been. And was there, if I say there was like a lot of hyperbole, would that make sense? People blowing things out of proportion? Is that something that you saw or heard about, I should say?
Is that a yes?
Yes.
Sorry. We just have to record, so everything has to be yes or no. Can you recall anything in particular about that experience or what was told to you?
No, I can't recall. It's been a while.
That's fair. That's fair. I don't want to put you on the spot too much. Mr. Davenport, you also raised your hand as well. Was it the same thing? Was it like a contentious divorce?
Oh, sorry, I didn't.
Oh, you didn't? Oh, I apologize. I apologize. I thought I saw your hand raised. And Ms. Rice, I know your hand was not raised. Mr. Smith, I'm going to jump over you. Mr. Keys, is that correct?
Yes.
Same thing. Was it a contentious or a lot of back and forth? No? Straightforward and simple? Manageable?
Get done, get out.
Okay, sounds like a plan. Mr. Smith, then. I can imagine even in your job as a former police officer, you've probably seen a lot of contentious couples. Is that fair to say?
Yes, sir.
Have you ever seen people blow things out of proportion?
Absolutely.
Can you think of anything off the top of your head?
Wow. Someone is alleging that this person did this to me, but then the physical evidence doesn't match up.
Going on that, is physical evidence something that you find to be important along with people's statements?
Physical evidence or a witness.
And if a witness says something along the lines of it was raining that day, and they have pictures from that day outside, let's say, would you expect the ground to be wet? I guess in a picture.
If it's close to the time of the event, yes.
Okay, fair. But there should sometimes be evidence that corroborates people's statements. Is that fair to say?
For the most part, yes.
For the most part.
Not always.
And as an officer, eyewitnesses can be some of the most difficult evidence there is. Is that fair to say?
That's correct.
It's very general, again. In your experience, why is that?
Well, each person interpret things differently. Yes. Take the three of us here that see an event, but when we go to interview us, we may have different explanations or and how we saw it because of all of our past experiences, eyesight, ability to hear. It's a bunch of stuff that plays it.
Ms. Rice, what do you think about what Mr. Smith had to say just regarding people's perspective, I guess, on things? Is that something you're familiar with or seen before?
Yeah, I agree that people have different perspectives based on how things happen, also how they remember things that can get jumbled up too with time.
So you're board certified behavioral analyst. Did I get that right?
Yes.
What in the world is that?
So I actually work with kids with autism. I work in a pediatric clinic with young kids with autism, and I kind of analyze their behaviors and why they engage in specific behaviors and make treatment plans for them.
Okay. So you can't look at me right now and say, oh,
No.
when you were 15, you got an MIP or something?
No, and
Okay.
it's not judging like how people are reacting to things. It's solely with my clients that have autism.
And maybe not necessarily in your line of work or anything, but have you ever seen things get blown out of proportion?
Yes.
And can you think of an example of something that's happened before?
Off the top of my head, I can't think of anything specific, but I know it happens all the time, just even at work. As well.
Okay. If I say people speaking hyperbolically, what does that kind of mean to you?
I don't really know.
Okay.
I'm not very familiar with that word.
I'll just move on from that one. Sorry. The I'm only hesitating. I don't want to mess this up. Miss Bushell?
Usha.
Bushell?
Yes.
Messed it up anyways. I'm sorry. You didn't think I was going to miss you, did you? Ask me these questions. What are your thoughts so far? What Mr. Smith had to say, for example, like the different people's different perspectives? Is that something you have seen before? People giving different?
Oh, well, for sure. I mean, I agree with what you said as well. That based on our own personal experiences, hearing sight, different factors, the way that we interpret something can be unnecessary as far as other people may have interpreted something.
Okay. And you're a security officer, is that right?
Yes.
Okay. Have you ever had a situation where someone was acting out or kind of made a big scene or something along those lines?
Yeah, every day.
Okay. And have you ever had to testify before or been called to court before?
I've never testified. I actually am involved in a case currently. I don't know, I don't want to go to it, so I don't know if I'm supposed to or not.
Okay,
An assault against me.
gotcha. So you're currently a victim in an ongoing case or something?
Correct.
Okay. With that, is that through Ingham County?
I believe so.
Okay.
I have the details. I haven't followed up with anything yet.
Okay. And were charges issued against the?
Yes.
Okay. Do you know, have you spoken with anyone from the prosecutor's office?
I got an email. I haven't spoken to anyone. I don't know if I have to appear or not. I really haven't followed up on it, which I probably should have.
Okay. With that case potentially going on, with your relationship with the prosecutor's office, do you feel like you could be fair and impartial? Do you feel like, things are a little skewed right now just because of the situation you're in currently?
I want to answer honestly.
Yeah.
And honestly, I don't think.
Okay. No, and I truly appreciate that, okay? I'm not trying to put you on the spot or anything, even though I am. But I appreciate your honesty. Thank you.
You said you don't think she can? So
That's correct, John. Okay. Finally, I'm gonna ask a very seemingly simple question. It may seem a little silly at first. I'm gonna go just down the line here. What's your favorite board game and why? So, Mr. Bogus, what's your favorite board game and why?
Arc Nova,
Okay, why is that?
mechanics I like.
Mhm.
I love building, engine building.
Okay, yeah, I'm not familiar with it, but it's it sounds almost like an engineering sort of thing, like building up and.
You're building a zoo.
Oh, okay, great. And you're a librarian, is that correct?
I work at the library,
Is that here in town?
MSU Library.
MSU Library, okay, my sister's a librarian, not in Ohio or something, but that's, yeah, I think we have someone else who's also a librarian. I've never had so many librarians on my jury pool before. All right. All right, Mr. Davenport, how about you? Same question.
Monopoly.
And why is that?
It kind of helps in real life.
Mhm.
With, houses and stuff.
Yeah. Managing budgets and whatnot. You kind of enjoy that oversight on things, or the meticulousness, or just kind of the wheeling and dealing? Okay. Ms. Rice.
I think Candyland, and I play a lot at work, so not a lot at home, but I think it's just great to play with younger kids and they work on color matching and stuff. I don't play a lot of board games at home.
No, that's fair. And it's also, is it a learning tool, I assume?
Yes.
I don't want to be rude, but I'm going to skip over you unless you're dying to answer. Okay. All right. Well, Mr. Smith, I'll tell you what is your favorite board game and why?
Monopoly, because it's the last thing I can remember if I was playing.
Okay, that's a good answer.
I haven't done that in 100 years, so
Fair enough.
about the last time I was on jury duty.
Mr. Keys?
Probably Scrabble,
Scrabble? Why is that?
probably the last one I played through.
Mr. Smith?
Big Monopoly as well, and that's because it's simple.
Mhm. And my name is Rochelle.
Yes. Probably Super Mario Party. It's a video game, board
Mhm.
game, but it's a board game.
And why is that?
It's a game of chance. It's exciting to see, when your odds are greater versus when they're not. Okay.
Okay, thank you. Your Honor, I have no further questions. Thank you.
Thank you. Any challenges for cause?
This time, Your Honor, I believe people would call it challenge for cause jury number 7.
Any objection?
Your Honor, for cause, no objection.
Make an excuse juror number 7. Replace juror number 7 with David Groner,
Yes.
who takes seat number 7. Any other challenges for cause, Mr. Broadway?
No other challenges for cause, Your Honor.
Any challenges for cause, Mr. Mills?
Yes, Your Honor. Juror number 4, under court rule 2511, he has already served on a juror of the same issue, essentially assault and battery, under paren 6, Your Honor. I'm sorry. Paren 6. I believe that's just for statute. He's already served. I think for cause purposes.
Thought he said it was for bullying.
I can't remember. It was two high school girls way back, and I'm not sure exactly.
How way back?
Like I said, it's 100 years ago.
You said what?
I said, like I said, it's 100 years ago.
It was
Back in
100 years ago?
91. You got a lot of people running around. In 91.
I was around.
I was.
Yeah,
I was too. Not an adult, of course, but I was around.
Judge, just going off the court rule itself, that the grounds for challenging a cause is that specific reason.
We don't know that because he can't remember if it was bullying or an assault.
I think he did say it was a criminal case in nature. Whether bullying or whatnot, he said it was assaultive in nature. It's close enough to the rule, Your Honor, but I would just challenge for cause.
Any objection?
People would not object to it.
Thank you. Excuse juror number 4. We're gonna replace juror number 4. Josiah Dalton. Any preemptory?
People would like to thank and excuse juror number 2, Your Honor.
Thank you, juror number 2. You may be excused. Any other preemptories as to this?
Nothing from the people.
Mr. Mills.
Thanks, Your Honor. Your Honor, the defense would like to thank and excuse juror number 5, Mr. Keys.
Thank you, Mr. Keats. Okay, we're gonna replace seat number 2 with Rachel Bullock. Seat number 5, Kenneth Pence. Now I have 3 new jurors. Careful. And you can voir dire your new jurors.
Thank you. All right, so now it's officially good afternoon, new people. So for everyone who's new up on the panel, you all heard the questions that I asked previously. Does anyone have any answers they feel that I should be aware of in regards to any of those questions? Okay, just to touch on a few of them again, nobody has had any involvement with the public defender's office, with the Ingham County Prosecutor's Office, nothing like that. Nobody knows myself or Mr. Mills for any of the witnesses. Okay. Does anybody have any friends or family in law enforcement?
My brother's a cop over in Farmington Hills.
Okay, and Mr. Hintz?
Yes.
Okay, and would your brother being a cop, would that impact your ability to be fair and impartial here today, one way or the other?
No, but not.
Okay. And then just to clarify, I believe the one other question I want to ask is, as Mr. Milk elaborated on a little more in his voir dire, this involves an altercation that involves people going through a divorce or related around the divorce. Does anyone feel that matters relating around those types of issues should be kept between individuals and not, they should be handled outside of the court? Does anyone believe that? Okay. No other questions.
Mr. Mills.
Thank you, Your Honor. Mr. Hintz?
Yeah.
Right out of the gate, I'm coming here.
Perfect.
The, you said your brother is a law enforcement?
Correct.
In a criminal case, would you expect there to be a police officer to testify?
No, I wouldn't expect it, no.
Okay, have you ever seen or talked about testimony that your brother has given in court or times that he's been to court or anything?
No, he's a rookie officer. I think he just completed the year, so.
Okay, great. What law enforcement agencies are you?
Farmington Hills.
You said that. Thank you. Yes. If I were to, I'm sorry, if I were to go after the investigation, whether or not it was bad or whether or not there were things that were overlooked, do you think that'd be something that you'd be able to objectively look at? Do you think maybe you'd have some concerns just based on your relationship with your brother at all?
No, I could objectively look at that.
Okay. All right. Thank you, sir. And favorite board game and why?
Catan, strategy based.
What color are you every time?
I let everyone pick first.
Okay.
So that way when I win, they can't blame it on that.
All right. And Mr. Groner, are you able to hear me as I'm talking right now?
I can hear you.
Okay, if things are a little bit softer, can you still hear okay?
If I watch your lips, I can understand.
So if I talking like this right now, can you hear me at all?
I can hear.
Okay. Can you hear what I'm saying distinctly?
That's the problem. I don't.
Okay. If you're not able to see a witness move their lips, does that make it more difficult for you to understand what's going on?
Follow, yeah. I
Okay.
hear, but I don't follow the conversation.
Okay, thank you. If the judge were to allow it and you were to move so that you could better see the witness, do you think that'd be easier, or would you still be concerned about your ability to hear?
I would still be concerned, but it would help.
Okay. Dalton, right? Is that correct?
Yeah, that's correct.
You're currently a student, is that right?
No longer.
Okay. And yes, then what's your favorite board game and why?
I'll probably say Monopoly.
Okay.
Because I just grew up playing it.
Okay. You play it often or?
Not really. I haven't played it in a while, but I played it a lot when I was young.
Okay. And let's see. I got to pose this to the other individuals, but have you or a friend, family member, someone along those lines, ever had to go through a divorce before? Have you seen or heard people who've gone through divorces before? No. Have you ever been in situations where maybe one person says, "I saw this," and regarding that same incident, another person says something different? Have you ever seen something like that before?
Yeah, something like that.
Can you remember a specific time that occurred?
Not necessarily.
Okay.
Because it wasn't too much of a big problem.
Okay. In a situation like that, I know you can't remember one specifically, but in a situation like that, how would you determine whether or not, or who is telling the truth or who isn't telling the truth, or trying to figure out what's going on?
Mainly just by common sense.
Okay.
And what would make logical sense in the situation.
Okay. Bullock, is that correct?
Yes.
Okay. You're a preschool teacher, is that right?
Part-time.
Part-time. I know they're little, but there's probably a number of disputes that happen from time to time. Is that fair?
That's fair.
Okay. And I know it's a little bit different, obviously, but when two kids are saying like, "Oh, this person took my toy," or this person took something, and they're saying two different things, How do you resolve or how do you approach a situation like that?
I like to listen to both of the little ones and compare it to what I'm seeing with my eyes, and we kind of move on from there.
Okay. Is it important that along with statements, there be something to kind of support or corroborate the child's statement or someone's statement in general? Is that something you look for?
I would say so, yes.
Okay. And same question to you. Favorite board game and why?
I don't play many board games. I like cards.
Okay.
Recently, we've been playing 5 Crowns.
Is that a poker game or?
It's you make either a run of 3 cards or 3 of a kind, and you try to get the first one out.
Okay. And why is that your favorite game?
We've been playing it a lot, but I like the strategy to it.
Okay.
It's fun to beat my husband.
Yeah. Then I'm sorry, I'm gonna come back to you, Mr. Hintz. We started, and we're gonna end with you here. You are the administrator, sports administrator. No,
Athletic director.
Thank you, athletic director. Do you deal a lot with students one-on-one?
Sometimes, yeah.
Is it usually like in a disciplinary sense more often?
Can be, yeah.
I know there's a lot of procedure involved with students in trouble or something, but if there is something that does occur at the school, some sort of incident between 2 students, how do you approach that, or how do you determine kind of what's going on, or trying to get to the bottom of it?
Kind of look at what's put in front of me. Usually it's coming through an email or verbal, kind of, someone did something. From there, go to the camera system. From there, the camera system kind of coaches from coaches. I have a principal and upper administrator, so we do it collaboratively as a team.
I know you probably interviewed the students who were involved in a situation, I assume.
Yeah. For if we're going into this, is more kind of the principal does a lot of this. Might more eligibility with grades, things like that, or an altercation at a game would be somewhere where I would jump in.
Okay. But it seems like you first go for sort of these collateral pieces of evidence, camera, other people's statements, someone who's not directly involved with the situation. Is that fair to say?
After I kind of listen to their stories, yes.
Okay,
yeah.
Fair enough. Kind of piggybacking off what I said earlier, is that, do you see people can be rather hyperbolic or really kind of, blowing things out of proportion or really amping things up, even though it's maybe less severe than it actually was?
Yes.
Are there situations where there's just bad blood between 2 people?
Yes.
And does that impact how your decision making goes?
Mm-hmm.
Is that enough?
No, it does not impact my decision making.
If there's a bias one way or the other, like that bad blood, I guess what I meant by bad blood, like this person just doesn't like another person.
So they had history or something.
Something like that.
Yeah. No, it would not impact.
Okay. All right. Thank you, sir. I appreciate it. Thank you. I have no further questions.
Just because. You may. Challenges for cause.
No challenges from the people, Your Honor.
Any challenges for you, Mr. Meltz?
Your Honor, my only concern is Mr. Grunner and just his ability to hear. I know he said if there were some accommodations that might make things a little bit better, but he did express some concerns just regarding his ability to hear, even if you were able to face the witness, Your Honor.
Mr. Grunner, can you sit in that seat right there in front of the jury? Yes, sir. Okay. Are you able to follow me?
Yeah.
Okay. Did that present concerns for your ability to follow the witness who will be sitting right here? Can you hear and see?
I think I could follow them.
Okay. And have you been following things that I've said this entire time?
When I can see you.
Okay, so when you were sitting there, I didn't really say much, but you were sitting there before you could follow me?
Yeah, I could follow you.
Okay, so as long as you can see, because you can hear with that device, correct?
Yes.
And so putting the visual together with that, you're able to follow?
Yes.
Okay,
I would just leave in the court's discretion.
okay. I think he's fine now that he's been accommodated as it relates to his ability to see. He'll be able to see the witness better than I can.
No other cause, Your Honor.
Thank you. Any preemptory?
Nothing from the people, Your Honor.
Your Honor, the defense would like to thank and excuse juror number 5, Mr. Hintz.
Thank you, Mr. Hintz. You may be excused. Any other preemptories as to this panel? None?
No, thank you. Sorry, thank you, Your Honor.
No problem. Okay, we're gonna replace Mr. Hintz with Kelly House. So Brodowitz, you can watch the new.
Thank you.
Sure.
All right, yeah, so Ms. House, good afternoon. So you've heard the questions that I've asked the other jurors. Is there any answer you particularly want to make me aware of? Kristen?
I was like this question to be whether or not to be on a jury probably 15 or 20 years ago. I didn't make it to the.
Okay, so you didn't actually serve on the jury, but you were pulled for jury service. Okay. And then just again to clarify, any interaction with the England County Prosecutor's Office, Public Defender's Office, any of the witnesses, anybody like that that you recognize?
No.
Okay. Any friends, family members, anything like that that have been victims of an assault or anything like that?
Yes.
Okay. And friends or family members?
My sister was assaulted probably 15 years ago. It was an anonymous street incident that did not.
Okay. And would that experience impact your ability to be fair and impartial here today?
No.
Okay. No other questions, here.
Mr. Jones?
Thank you. Good afternoon, Ms. House. You're a journalist, is that correct?
Correct.
You work for a particular company?
Yes, I'm a staff reporter at the Environment for an outlet called Bridge, Michigan.
Okay. And for the Environment, do you cover much in the way of criminal cases or anything like that?
Not typically. I mean, occasionally, lawsuits. That type of thing.
Okay. The like I know that there was like the People's Something March over there for environmental purposes. I don't know if you've been involved in any stories like that or something, but
I was not involved in that particular thing, but I do occasionally cover protests.
Okay. Okay. And as part of your job duties, I assume there's an investigative role you kind of play. Is that fair to say?
Yes.
And I apologize, this is a very broad question, but in a general sense, what's the extent of your investigation?
It depends upon the nature of the story, most of my work is daily stories covering current events, but occasionally I'm investigating. I was involved in an investigation of the Chatfield. I occasionally will investigate like corporate conduct when it comes to environmental issues.
And like corporate issues, do you just talk to witnesses? Do you look at, is there, I assume with especially with the environment, there's probably more data that's involved looking at, lead or things of those nature. Is that something that you look at? Do you just talk to witnesses? Is there like more of a scientific element to your investigating?
All of the above: witnesses, documents, data on, the rate of whatever, cancer in a certain zip code, that kind of thing.
And there's a certain responsibility you have, making sure that you're reporting on the truth, is that right?
Yes.
Has there come a time where you feel like there's a story somewhere, but you just don't have the evidence for it?
Yes.
And if that was the situation where you just didn't have the evidence for it, would you still report on it anyways?
Not if I couldn't corroborate what I thought was happening.
And just a little earlier, you said the nature of the investigation. Is that a fun pun for environmentalists, I assume? Or is that?
I haven't thought about that.
No, I'm just, all right. Finally, Ms. House, favorite board game and why?
I also like Settlers at the time. It's just a fun one and a lot of my friends like to play it.
Okay. I have no further questions, Your Honor. Thank you. Thank you.
Challenges for cause.
No challenges for cause, Your Honor.
None for cause, Your Honor.
I'm satisfied with this panel, Your
Defense is satisfied as well. Thank you.
Okay, ladies and gentlemen, it looks like we have a jury. And for those of you who are disappointed that you didn't get selected, you have a better chance tomorrow, maybe, if any of the other courtrooms are running a trial. But I thank you for appearing today and being willing to participate and serve your most fundamental, or one of your most fundamental civic duties. We're going to excuse the remainder of you to follow Ms. Kneeling out. And then the others, I'll give you some further instructions before we take a break for lunch. All rise. Okay, and you can be seated. Okay, back to the screen for some additional instructions. Ladies and gentlemen of the jury, you have been chosen to decide a criminal case made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If you have a religious belief that does not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. If you could all rise. Raise your right hand. Do each of you solemnly swear or affirm in the action now before the court that you will justly decide the questions submitted to you, that unless you are discharged from the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court? If you do so, please say I do.
I do.
Thank you. You can be seated. You will receive a written copy of the instructions I'm going to read to you, but you won't receive them until it's time to deliberate. You won't be able to refer to them during the trial because of that purpose. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, again, I will provide you with a copy of my final instructions for your use during deliberations. Now I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. First, let's go over the elements, which Mr. Brodowitz did briefly go over during his voir dire. The defendant is charged with the crime of assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, God bless you, that the defendant either attempted to commit a battery upon a William Rayborn and or April Rayborn, or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful, violent, or offensive touching of a person or something closely connected to the person of another. Second, that the defendant intended either to commit a battery upon a William Rayborn and or April Rayborn, or to make William Rayborn or April Rayborn reasonably fear an immediate battery. An assault cannot happen by accident. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought he had the ability. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about June 4th, 2023 within the city of Lansing in Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. If the defendant is not required The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful, considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyers has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence but does not have to. By law, the defendant does not have to prove his innocence or produce anything. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence in the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of the case is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject anything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to make an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or influence that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my own opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to the court staff, who will give it to me. Do not show your questions to other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand. That should say immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyer and I, or the lawyers and I, will have discussions out of your hearing, which we've already done today. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury for that purpose, or to the jury room for that purpose. Then you should discuss this case among yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone else who may be connected to this case. This means that you may not speak to these individuals even if has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of an improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, please tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave. Report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider any or as evidence any personal knowledge you may have of the scene. You must not share any information about this case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see that we have chosen a jury of 7. After you have heard all of the evidence and my instructions, we will draw names to decide which one of you will be dismissed to form a jury of 6. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let prejudice, bias, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about the case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. That concludes the procedural instructions. It is now 12:39. We are going to recess for lunch. You have already been sworn in as jurors for this case. And so that means that the instructions that I've just read apply to you. You cannot speak to anyone connected to this case. That includes the attorneys. And so if someone does speak to you in the hallways, you don't know who they are. They could be potential witnesses. So you need to avoid making communications with any individuals. There are some restaurants down here on the main strip on Washington. If you'd like to grab some lunch, there is a jury room back here, which will be locked, and you all are the only individuals who have access to that during the jury trial. So you're welcome to bring your lunch back here. I have at 1:30 to arrange some people. So this is a perfect time to take a full hour because I am going to have to arrange some people before we come back. We'll come back probably around, you should be back here by 1:30 in that jury room. I expect to go back on the record no later than 1:45, and then we'll proceed with opening statements at that time. Does anybody have any questions? Okay. All rise for the jury. We'll be in recess until 1:45.